Hello and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Goeringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics with the University of Maryland. And today we're going to look at an issue that I like to talk about on the podcast from time to time, which are right to farm law decisions that have been coming out around the country. And today we're going to specifically focus in on the state of Indiana. Recently, the Court of Appeals of Indiana upheld a trial court's decision applying the state's right to farm law in a case involving a hog farm. In this case, the right to farm law applied to claims that the neighboring hog farm was creating a nuisance. So it acted as a defense in this case. Although over the past 18 months, we have seen decisions involving these laws in other states not applying to agricultural companies, farmers, and many of them being hit with high damage verdicts. It's crucial to remember that in many cases, this defense still applies and it continues to prevent these large verdicts that we've seen in other states. So to give a little bit of background on this, Samuel Himsel's family acquired farmland in the early 1990s, which had been in agriculture since at least 1941. Between 1994 and 2013, the property was consistently used for crop production. In 2013, Himsel and his sons began to operate a hog operation on the farmland. Before starting the operation, Himsel petitioned the County Planning Commission to rezone the farmland from agricultural residential to agricultural intents to allow for the development of the hog farm. At the public hearing, a few neighbors spoke out in opposition to this zoning request, including Richard Himsel. Richard, from what I can tell, is a cousin to Samuel. The county commissioners unanimously approved the planning commission's findings approving the rezoning. None of the neighbors appealed the rezoning decision. This is going to become important down the road. Shortly after the rezoning approval, the Indiana Department of Environmental Management, or IDEM, approved 2 permits to allow for construction and operation of the hog farm. No neighbors appealed the permits approved by IDEM. By late 2013, Samuel and his sons had entered into contracts raising hogs in the newly constructed buildings. Neighboring Samuel Himsel was Richard Himsel, again his cousin, who had lived on Richard's property. Richard had lived on his property since about 1994 and had raised livestock there until about 2000 when he retired and sold the farmland. At one point, Richard also operated a large hog farm on his farm for 2 years before a fire destroyed the buildings and he did not rebuild. Robert Lannon, another neighbor, built his house in 1971, but his property had never been used for agriculture from what the court could determine. In 2015, Richard Himsel and Robert Lannon and their respective wives sued Samuel Himsel and his sons. In the lawsuit, the neighbors claimed nuisance, negligence, and trespass, along with claims that the right to farm law was unconstitutional. Samuel Himsel and his sons answered, raising the right to farm defense, and moved for summary judgment. In 2018, the trial court granted Samuel's motion for summary judgment on all claims. The neighbors appealed this decision, and this gets us to the Court of Appeals decision. So if we look at the Court of Appeals decision on appeal, the neighbors argue that the right to farm law defense did not apply based on the language in the right to farm law requiring the operation would not have been a nuisance at the time the agricultural operation began on that locality. With this argument, the court looks at when the agriculture or the farming operation began. A row crop operation had been started on the land around 1941 from what the court could determine, and the neighbors' non-agricultural uses began around 1971 from when we look at when Robert built his house. The farm had changed to a hog farm in 2012. Based on the 2005 amendments to the right to farm law in Indiana, the switch to a hog farm was not significant enough to change to the farm to bar the right to farm defense. The amendments broadened the defense defenses coming to the nuisance defense to encompass all future nuisances. To the court, agricultural uses dominated the area. The neighbors had moved into. Some of the neighbors even kept livestock on their own properties. The county's planning commission and county commissioners recognized the agricultural nature of the area where the hog farm was built and attempted to maintain the agricultural nature of the portion of the county. The nature of the area helped to demonstrate that the area in question was agricultural and not residential, and the hog farm would not have been a nuisance when it was established in 1941. The court also disagreed with the neighbors' arguments that allowing the right to farm defense would allow large hog farms and other concentrated animal feeding operations of any size to be built in areas with a history of agricultural use. To the court, this ignored the basic administrative process most farmers have to work through to build a large CAFO. In reviewing the regulatory process which farmers go through to build, the court points out the neighbors had an opportunity to challenge the building of the hog farm, but chose not to do so. They never appealed the decision granting the environmental permits to start the hog farm. Looking at the exception in the right to farm law, nuisance suits resulting from negligent operation of the farm, the neighbors offered no evidence demonstrating the hog farm was negligently operated or violated any of the state regulations related to CAFOs. The neighbors did claim that the hog farm was negligently sited and should have been construed as a negligent operation. Siting would be the decision on where to build and operate the hog farm. The court disagreed that negligent siting would create a claim of negligent operation to create an exception to the right to farm law defense. So why in the end should you care about this if you're located in Maryland or another state that's not Indiana? Well, right to farm laws continue to be in the news as neighbors challenge nearby animal operations. We've seen these news stories over the past few years if you paid attention to any of the ag news, where decisions have been highlighted, where courts have held right to farm law defenses do not apply. But in the majority of states, these defenses continue to be valid, and this case helps shows that these laws still, in essence, do what they're supposed to do and provide a defense to nuisance claims. As I've discussed here on the podcast and in prior posts, discussing right to farm laws, decisions like Himsel highlight why agricultural operators and neighbors must understand how right to farm laws operate in their respective states. One thing I did not include were any of the arguments that the right to farm law was unconstitutional. The Court of Appeals basically rejects all these arguments. Many courts, when presented with a case arguing that the state's right to farm law is unconstitutional, typically reject these. Currently, the only state where the right to farm has been found unconstitutional as applied is in Iowa. The law is still constitutional, but in most cases, when it's applied, it's been found unconstitutional. The final issue not addressed is attorney's fees. And I highlight this because Indiana's right to farm law allows for attorney's fees in certain situations. In Indiana, attorney's fees will be awarded when the court finds a nuisance action frivolous. At this point, the neighbors may still appeal to the Supreme Court of Indiana. That's still on the table. I think they have a few days left as of the posting of this podcast episode. We will have to see if the verdict is upheld there or even if the Supreme Court accepts, to hear this case in Indiana. And then when it gets back to the trial court, we'll have to see is Samuel Himsel and his son's going to request any attorney's fees in this case. So thank you again for listening to today's episode. If you have any questions about it, please email me at lgoering@umd.edu, or you can tweet me at aglawpaul or find me on Instagram at aglawpaul. Thank you for listening and enjoy the rest of your day.